Welcome to SCOTUScast, Patent Trial and Appeal Board and Inter Partes Review Edition. Thank you for tuning in. On June 20th, 2016, the Supreme Court decided Cuozzo Speed Technologies, LLC v. Lee. In 2011, the America Invents Act created an expedited procedure known as inter partes review to provide a cost-effective alternative to litigation for resolving certain challenges to patent validity. The Patent Trial and Appeal Board, contained within the U.S. Patent and Trademark Office, hears these disputes rather than a federal district court. When construing patent claims, the board applies a broadest reasonable interpretation standard rather than the plain and ordinary meaning standard typically applied by federal courts. Here, Cuozzo Speed Technologies LLC owns a speed limit indicator patent. Garmin International Inc. petitioned the board for inter partes review of claims regarding the patent. The board found that certain claims were unpatentable and denied Cuozzo's request to replace those claims with several others. Cuozzo appealed the board's decision on the U.S. Court of Appeals for the Federal Circuit, which 1. held that it lacked authority to review the PTO's decision to institute IPR, and 2. affirmed the board's final determination, finding no error in its application of the broadest reasonable interpretation standard. There were 2 questions before the Supreme Court. 1. Whether the Federal Circuit erred in holding that the board may, in IPR proceedings, construe claims according to their broadest reasonable interpretation, rather than their plain and ordinary meaning. And 2. Whether the federal court erred in holding that, even if the board exceeds its statutory authority in instituting an IPR proceeding, the decision to institute the IPR proceeding is judicially unreviewable. By a vote of 8-0 and 6-2, the Supreme Court affirmed the judgment of the Federal Circuit. Justice Breyer delivered the opinion of the court, which held that the underlying statute precluded judicial review of the kind of claim at issue here, including the PTO's decision to institute IPR. The court further concluded that the PTO is authorized to issue the regulation, setting forth the broadest reasonable interpretation standard. A unanimous court joined Justice Breyer's opinion with respects to Parts 1 and 3. Chief Justice Roberts and Justices Kennedy, Thomas, Ginsburg, and Kagan joined the opinion with respect to Part 2. Justice Thomas filed a concurring opinion. Justice Alito filed an opinion concurring in part and dissenting in part, in which Justice Sotomayor joined. To discuss the case, we have Gregory Dolin, who is Assistant Professor of Law and Co-Director, Center for Medicine and Law at University of Baltimore School of Law. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Professor Dolin.
The case presented 2 issues to the Supreme Court. First, dealt with how the Patent Office construes patent claims, and the second issue concerned whether or not certain of its preliminary decisions are subject to judicial review at all. Before getting into the court's decision, I will give some background on the statute and on the proceedings in the Patent Office, because that will help understand the issues the Supreme Court was facing. In 2012, Congress passed an act known as Leahy-Smith America Invents Act. The act meant to make it easier for certain patents to be challenged and to be re-examined and, if necessary, canceled by giving the Patent Office more powers to do all of those things in lieu of doing all of those things in traditional Article III courts. And the way it works is somewhat similar to litigation, where a challenger would bring a petition to the Patent and Trademark Office suggesting that certain claims of a patent are invalid for a number of reasons. They would bring an affidavit by some expert attesting as to why those claims are, in his view, invalid. And then the Patent Office would decide whether or not to proceed with a full-blown hearing. So that is the step 1 of the decision. If the Patent Office decides to proceed with a hearing, the Patent Office needs to construe the claims, in other words, needs to decide what those claims actually mean before deciding whether or not they're invalid or valid. In other words, the Patent Office needs to decide what is the scope of the claim, and because the broader the claim, the more likely it is to sweep within its ambit prior art, so things that came beforehand. And therefore, more likely it is that the broad claim will be invalid, because obviously a claim cannot be issued for something that has already been invented. So the Patent Office, pursuant to the claims authority that Congress delegated to it, decided that it will construe these claims at the second step of the proceedings within the broadest reasonable meaning that they could bear. Now, that was, in view of the petitioner, in view of Cuozzo, somewhat problematic, because had these very same claims been adjudicated in Article III courts, the claims would have been subject to a somewhat narrower construction, a construction that would be based not on what is the broadest reasonable meaning, but what would be understood by a person having ordinary skill in the relevant field of endeavor. So biochemist and a biochemistry patent, computer scientist and a computer science patent, and so on. And like I said before, a broad claim, while to an uninitiated person would seem a good thing, in reality is not so a good thing, because the broader the claim, the more likely it is to be invalid. So in this particular case, Cuozzo held the patent. A petition was filed challenging explicitly a single claim of a patent, specifically Claim 17. But Patent Office decided to institute review. So at this first stage, they looked at the petition. They decided to institute review not just on the one claim that was challenged, not just on Claim 17, but also on Claims 10 and 14. And ultimately, at the second stage of the proceedings, while evaluating all three of those claims under the broadest reasonable construction, invalidated all three of them. Cuozzo sought review, first in the United States Court of Appeals for the Federal Circuit, and lost at a panel decision at 2-1, and then sought further review by the en banc court, and its petition for an en banc rehearing was denied by a vote of 6-5 over some vigorous dissents. And finally, Supreme Court took the matter up to resolve, like I said, two questions. First question is, was it proper for the Patent Office to institute review on claims that were not explicitly challenged? Or rather, is that decision reviewable by any federal court? And the second question was whether this broadest reasonable construction is the proper approach to deciding the scope of the claims at the second step of the proceedings. On both of those issues, the petitioner Cuozzo lost, and Michelle Lee, in her capacity as the Director of Patent and Trademark Office, prevailed. The Supreme Court approved the Patent Office proceedings on claim construction and decided that its initial decision whether or not to even institute a patent challenge at a full-blown hearing is not reviewable by an Article III court. In a decision written by Justice Breyer, on that first question, on whether or not the decision to institute is reviewable, Justice Breyer explained, speaking for himself and all other justices except Justice Alito and Justice Sotomayor, Justice Breyer explained that the statutory language explicitly says that decisions to institute are not reviewable. And Justice Breyer, together with the majority of the court, concluded that the statute means exactly what it says, that decisions to institute are not reviewable, either by when they're denied or when they're granted, and instead only the final decisions of invalidations can be challenged. Justice Breyer contrasted this case with some other case where the court said that there's always a strong presumption in favor of judicial review by stating that reading the statute in its fullness, it makes no sense to ignore what Congress has said. On this point, Justice Alito, joined by Justice Sotomayor, dissented, suggesting that this particular reading of the statute gives Patent Office too much unfettered power. As it happens, the ability to institute review is somewhat statutorily limited. So, for example, a review cannot be instituted if a party seeking this review had previously been sued on this patent and had waited for more than a year after a suit has been filed against it to petition the Patent Office for review. And so Justice Alito was worried about a situation where a Patent Office would just ignore that limitation on its own power and ignore that limitation on when review petitions could be brought if such decisions could not be judicially challenged. In somewhat passing response, Justice Breyer and majority opined that their decision probably doesn't preclude mandamus, though they left that point undecided. They did say that they do not expect the Patent and Trademark Office to completely ignore statutory limitations on their own powers. And in response, Justice Alito and Justice Sotomayor said that although they take the court at its word that Patent Office will not be abusing its powers, they don't see any way to make sure that such abuse does not happen in case that there's a plausible situation where it does happen. They don't see any way to enforce it. And so that's why on this point of whether or not decisions to institute review are or not challengeable, Justice Alito and Justice Sotomayor dissented. On the second point, and point that was, I think, of more interest to the patent community, the scope of the patent claim, and just sort of in the interest of full disclosure, I was an amicus in this case supporting Cuozzo. The second point, I think, was a more important point to this litigation. What is the scope of the claim? Because really, as Judge Rich, one of the preeminent judges, as late Judge Rich, one of the preeminent judges of the Court of Appeals for the Federal Circuit once said, in patent world, the name of the game is the claim. The validity or invalidity of the claim really rises and falls based on the claim construction. And so it was really important to the patent bar, for both the challengers and the bar that defends patents, was important to make sure that the Supreme Court speaks authoritatively on what is the proper way to construe the claims. And the court unanimously on this point decided that the Patent Office is doing it right. The reason they did so is mostly relying on Administrative Procedures Act and the delegation of authority to the Patent Office to craft its own rules in creating these new proceedings pursuant to American Invents Act. The Supreme Court brushed aside concerns that differing types of different standards for claim construction in Article III courts and administrative proceedings would often lead and do often lead to different results, where a claim could be valid if reviewed by Article III court, but invalid if reviewed by administrative agency. The court said that that is actually what Congress intended, and although there's some incongruity to it to a layperson, that is a perfectly legitimate two-tiered and two-track approach. The court further held that the past practice supports Patent Office decision to use broadest reasonable claim construction because that's how they've been using it for over 100 years in evaluating claims. Cuozzo, the petitioner, tried to convince the court that the past practice is really not all that informative because in the past practice, the Patent Office was construing the claims prior to patent issuance. In other words, they were testing the limits of the patent as opposed to trying to figure out what an issued patent actually means. They were testing the limits of a patent application, I should have said, as opposed to deciding what an issued patent actually means. Supreme Court was unimpressed by this argument. They said that the Patent Office construes the claims the same way all the time. And they were further unimpressed by the argument that these new proceedings were no longer examination-type proceedings, but quasi-judicial proceedings. They were unimpressed by the argument and apparently did not actually buy it. Justice Breyer's opinion states that although these new proceedings have some features of judicial proceedings, they also have some feature of traditional administrative proceedings. And so, having concluded that these are still administrative proceedings, that these are still to be conducted by the standards used in other pre-issuance proceedings, that parity makes sense, Supreme Court declined to overturn the Patent Office decision to use the broadest reasonable construction and ultimately affirmed the Federal Circuit, which then in turn affirmed the Patent Office decision to cancel these claims. Ultimately, of course, the decision is not about Cuozzo as such. It's not about their claims. It's not about their particular patent, which is why I didn't get into details of their specific invention. The decision is really about how will the Patent Office proceed going forward in evaluating these challenged patents, procedure that has become more and more favored by various accused infringers. And it seems that the Patent Office will continue to use the broadest reasonable construction, making claims easier to invalidate, and that its decision to institute review will not be challengeable in any way. The only caveat to that is that there have been a number of bills proposed in Congress. Right now, they're all in various committee stages. They have not moved yet, but there have been a number of bills proposed in Congress to equalize the review standards between the Article III courts and Patent and Trademark Office, and to mandate that Patent and Trademark Office uses the same claim construction as Article III courts do, so that there's somewhat of an equality of an outcome. Whether or not any of those bills will go anywhere, it's unclear. Whether or not, even if they do, whether it will be soon or not, it's unclear. But for now, the Supreme Court has unanimously affirmed the Patent Office decision to use the broadest reasonable claim construction, which makes patents easier to invalidate, and gave the Patent Office green light to make its own decisions whether or not to institute these reviews, in other words, at that first step, without being second-guessed by federal courts. So nothing has changed from before this decision came down, except that Patent Office can now feel secure that, at least as far as Supreme Court is concerned, what they're doing, they are doing right.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.